Thank you so much for tuning in and joining us for this presentation on the International Entrepreneur Parole Rule. My name is Dustin Saldarriaga, and I'm an associate at Scott Legal PC. So today, as I mentioned, we'll be discussing a new program that was announced last year called the International Entrepreneur Parole, or IEP rule, including what it is, how you can qualify for it and apply for it, and what it might mean for you. The IEP program fits closely with our firm's focus on investor visas and business-related visas. And one of the topics we'll discuss in this presentation is how to choose between IEP and other options like the E2 visa or the EB5 green card. A few things before we get started. This webinar is part of a series that will continue by doing at least 2 webinars per month, and we do those on a variety of topics. Even though our firm is focused on business immigration, we actually handle the full array of immigration issues, from family-based immigration to humanitarian immigration as well. So if you have any questions in any of those fields, anything related to immigration, please don't hesitate to reach out to us. We already have a number of webinars that are scheduled, and we'll be regularly adding more. At the end of this webinar, we'll be sending out the PowerPoint presentation that you see on your screen now. We'll be sending you a link where you can sign up for the additional webinars. And since this webinar is being recorded, we'll be sending a link to where you can find the recording itself. We also do post our webinars as well as a number of shorter videos on our YouTube channel. So the email you get after this presentation will also include a link to our YouTube channel. We really do try to make high quality information free on both our YouTube channel and our blog, which you can find on our website. So really, if you have any questions at all about any visa, do check out our YouTube channel and our blog. A few housekeeping items before we get started. I will reserve a few minutes at the end for questions. Please do feel free to send those in. You can do so by either using the chat function or the Q&A function on Zoom. I might not answer your question as soon as you send it, but I will review all the questions by the end of the presentation. Again, my name is Dustin. I'll be your presenter today. Before starting this presentation, I do want to just be completely transparent. We were all very excited about the International Entrepreneur Parole rule when it was announced last year, but it appears that the government has not done anything with the program. So applications have been submitted to the government, and I do not believe that a single application from any applicant has been decided yet. So we're really not sure. We are part of a large group of immigration attorneys that does speak with the government quite regularly. And one of the questions that is asked is, what is the status of the IEP program? And frankly, the government has given us no indication that it's moving on it. It does exist. It is, written in the regulations, but full transparency, the government has not done anything with the program. So I think one of the key takeaways from that is that the IEP is an option. It can be applied for. We don't know when the government will decide, but this reinforces the importance of considering other options. And frankly, like I said before, we do handle E2 visas, we do handle EB5 visas, and if you do qualify for those other options, they might be a better option since the government does move on those. So without further ado, let's go ahead and get started. So, the International Entrepreneur Parole Rule explained. The International Entrepreneur Parole Rule exists in the context of other investor visas. And like I mentioned before, the E2 visa and the EB5 green card are some of the most common alternatives to the International Entrepreneur Parole Rule. The E2 visa is a treaty visa. It is only for individuals who have passports, have a passport from what is called a treaty country, an E2 treaty country. There are about 80 countries that are E2 treaty countries. You can see the full list on the US Department of State's website. However, countries like India, China, Brazil, South Africa, those are not E2 treaty countries. So if you don't have a passport from an E2 treaty country, you cannot apply. That being said, those who were not born in an E2 treaty country can receive citizenship from an E2 treaty country through something such as citizenship through investment, through a country such as Grenada. And once they have a passport from a country like Grenada, they can apply for an E2 visa. So that is a quite common way that individuals born in China or India or South Africa or Brazil can receive citizenship and qualify for an E2 visa, at least insofar as the nationality requirement is involved. The EB-5 visa is the millionaire's green card, and that does require a minimum investment of about $800,000. So you start to see why the International Entrepreneur Parole Rule does fill a gap. The International Entrepreneur Parole Rule was intended to help those entrepreneurs who are starting a business with high growth potential and high potential to employ a large number of employees. But these individuals were not born or do not have citizenship from a treaty country, and maybe they don't have personal funds so that they actually can't invest in the business. But they might have interest from venture capitalists, from certain government grant organizations, agencies. And if that's the case, then the International Entrepreneur Parole Rule could be a good fit for them. And that really is the demographic that was that the government had in mind when introducing the rule. The International Entrepreneur Parole Program was initially launched in December 2017. The Trump administration did not do anything with it and crippled it. And then the program was relaunched in May 2021, although, as I said before, the Biden administration has done nothing with it, even though it is now on the books and you can apply for it. It gives foreign startup founders the ability to come to the US for up to 5 years in order to oversee and grow their startup business in the US. Applicants who are approved for IEP do not receive a visa, and this is an important point. They instead are paroled into the United States. Parole is an interesting idea. It's not the kind of parole that you might think of in the context of criminal law. Being paroled in immigration law is when the government basically gives you temporary permission to come into the US for a very specific purpose. And you're permitted to enter, but you do not have certain benefits that come if you enter with a visa, such as changing your status. You can't do that if you're paroled in. Parole is also highly discretionary. So if the border officer decides not to let you in, that really cannot be appealed. So those who receive IEP are essentially paroled into the US for the specific purpose of developing their startup business. The initial parole period is 30 months, 2.5 years. Those who qualify can reapply for another 30 months for a total period of 5 years of parole. Now, the spouse and children of the entrepreneur who receives International Entrepreneur Parole can accompany the entrepreneur or join them afterward, but they have to independently apply for travel authorization. And we'll talk a little more about what that means a bit later. And the spouse, once they're in the US, they can apply for work authorization by filing a Form I-765. And finally, as I mentioned before, the program can be an alternative to those other programs, for those individuals who don't qualify for an E2 or an EB-5 visa. We talked a bit about why that is earlier. So what is parole? We talked a little bit about this already. Parole is the government's ability to allow a person to physically enter the US without formally admitting them for purposes of immigration law. So parole is not the same as a visa. You don't get a visa if you are approved for International Entrepreneur Parole. Rather, those who receive IEP are allowed to physically enter the US one time in order to develop and direct their business. Parole, as I mentioned, is discretionary, so the border officer will make the decision whether to parole the person into the country on a case-by-case basis. And what they're supposed to do is consider the totality of the circumstances. Parole can be revoked at any time. For example, if the company is no longer in operation, or if the government decides that it no longer provides a significant public benefit to the United States. Now, finally, I'll say the denial of parole is not subject to review by a court. So there's really no appeal before a judge if a border officer decides to deny you parole, or if a consulate decides to deny parole. All this does sound scary, but the government has been quite clear that if you do apply for IEP and if you are approved for it, you should be admitted. And that family members who apply for travel authorization should be approved if the principal applicant, the entrepreneur, is approved. So I share all of this to share the full context of what parole is and what the government's powers are really. But the fact is that once the program gets rolling, is operational, and people are approved for it, we don't expect that there will be many instances where the consulate will approve parole and then the person will be denied entry at the border. If they've been approved IEP, International Entrepreneur Parole, they really should be admitted. Unless there's some issue that's separate from their qualification as an entrepreneur, such as if they have a prior immigration violation, something like that. So what are the requirements for initial parole? Remember that the way this works is that you apply for an initial period of 30 months. And then at the end of that 30-month period, you can apply to renew that 30 months. So apply for a new 30-month period for a total of 5 years in the US. So to receive initial parole, that initial 30-month period, the applicant has to show that they, the entrepreneur and the business, will provide a significant public benefit to the United States, and that the business has substantial potential for rapid growth and job creation. That is a really important piece to keep in mind. And that's because, as we'll talk about, there are ways to, especially if you don't satisfy the investment requirement in the business, we'll talk about that in a minute, you can go back to this requirement that the business have substantial potential for rapid growth and job creation, and show the government evidence that that's the case for the business. And that even though the business hasn't received a significant investment amount, they do, through evidence that we'll talk about, they do have the potential for rapid growth and job creation. So if your business does have that potential, there are ways to get around other weaknesses in the application. So let's talk about the qualifications. The entrepreneur, and these cannot be substituted. It's the third piece that can be substituted. So the first piece, which is non-negotiable, the entrepreneur must own at least 10% of the startup business and have a central and active role in it. They cannot be a passive investor. Second, the startup business, which can be an LLC, a partnership, a corporation, really any legal entity, must have been established in the US within the past 5 years. All right. And it must show demonstrated potential for rapid growth and job creation. And finally, this third piece, which is the piece that I was talking about before, that even if you can't satisfy this third piece, there might be a way to be approved. The startup business must have received investments of at least $264,147 from qualified US investors, or government funding of at least $105,659 in grants or awards. Now, what is a qualifying investor? That is US citizens, green card holders. They have to have an established track record of successful investments. So it cannot be a family member. It can't be a one-off investor. It really should be, say, a venture capital firm or something like Y Combinator, some sort of an entity that has a track record of investing into businesses. And the government kind of uses this as a kind of test to say that if an established venture capital firm or an entity like Y Combinator is willing to invest in the business, well, then the government should feel more comfortable granting parole to the entrepreneur. They really do look to see if others have approved the business, then we as the government are also okay approving the business. Now, as I said before, applicants who only partially satisfy this third criterion do have an alternative. So what is that? In general, it is to emphasize to the government that the startup entity truly does have the substantial potential for rapid growth and job creation. So how can they show that? They can provide documents that show the entrepreneur's background, that they really do have expertise in the field, that they have a track record of success, that they have the ability to advance this specific startup. You can include evidence of the startup's being selected to very selective or reputable startup accelerators, for example, or by certain venture capital firms. You can provide evidence of the likelihood of a national impact by the startup if it really does have a focus that pretty clearly will benefit society, maybe directly address a problem that is widely acknowledged, then that can be used as evidence that there really is substantial potential for rapid growth of the business. And keep in mind the scope of that. It is okay if the business is not necessarily going to have a national impact. If the business is likely to have an impact on a city, a town, a state, that can be okay. Really, this is an opportunity to advocate for yourself, or where your attorney would advocate for you, and really look at the full list of evidence and really look at the business and the entrepreneur as a whole and try to make the strongest case that this really is a business and an entrepreneur that is going to create a business of high growth and that's going to employ workers. You can also include corporate or tax records that show the number of customers that the startup has, its revenue, and jobs created by the startup. You can include evidence of additional investments or fundraising, such as through crowdfunding, or here is an area where you can show that individuals, maybe a single individual, has given money to the business. You can't use that to satisfy that third requirement we talked about before. So here, the individual would not qualify as a qualified investor, but keep in mind that what we're talking about on this page, which is a substitute, is really pulling in all evidence that would suggest to the government that this really is a business with high growth potential. So there you could say, we've raised through crowdfunding $1 million or whatever it is you've raised. Letters from government agencies, investors, or business associations that have knowledge of the startup's product or services. You can include all those letters in support of your argument that the business has high growth potential. You can also include press coverage. And finally, patent awards. So if you've been awarded a patent, include that in your evidence. This is just a list of examples. So if there are aspects of your business that are persuasive, throw that in, even if they're not on this list. If you're applying on your own, or if you're working with an attorney, we would certainly work with a client to pull that into the application. So this page is really just building on the last one. It's going into specific documents that you can use to show a few of the examples we had before. So how do you show that the entrepreneur has a central and active role? You can provide evidence of any degrees that the entrepreneur has. You can include letters that they've received, essentially endorsement letters or letters of reference from startup accelerators or from government agencies, anyone that the entrepreneur or the business has interacted with that can speak to the high growth potential of the business. You can also, like we discussed before, point to the award of patents. If they're in the entrepreneur's name, it shows that the entrepreneur has a central and an active role. Evidence of the entrepreneur's ownership share. This is quite straightforward usually, and you typically provide the documents that show the formation of the entity. So the LLC formation documents, the articles of incorporation for a corporation, tax records, if taxes have been filed for the business, would usually show who owns the business. And finally, financial records might show the ownership share. An operating agreement as well would oftentimes show the percent share that the entrepreneur owns. Evidence that the investment funds are from a qualified investor. This is really gathering tax records, bank records, and frankly, identity documents from the individuals or entities that have invested in the business and showing that they really are qualified investors. If you are applying on your own and you're not working with an attorney, our recommendation in general is to work with an attorney. There's really no substitute to working with someone who's navigated the process and knows the pitfalls. But if you do decide to apply on your own, one of the most valuable resources is to use the instruction page of the form. So the form that's used to apply is the form I-941. We'll talk about it a little more later. If you Google form I-941 instructions, you'll go to the instruction page. And the government tends to put a lot of critical information in the instruction pages. And in the I-941 instruction pages, it has details on really all of this, what documentation you can use to prove the different parts of what you need to convince the government of to get IEP. So the instructions to the form are really a key resource if you're applying on your own and not working with an attorney. So finally, evidence that the investment amount is substantial. You'd include copies of the grant award and letters, really the bank records that show the transfer of funds to the business to show the actual dollar amount that the business has received from the specific qualifying investors. So what is the application process for international entrepreneur parole? As I mentioned before, the entrepreneur would file what is called a form I-941, the application for entrepreneur parole, with U.S. Citizenship and Immigration Services, or USCIS. That application will be mailed to USCIS, which is located in the U.S. That form can be filed whether you are inside the U.S. or outside the U.S. There is a bit of confusion around that, but the I-941 can be filed from anywhere in the world. Some have the understanding that you cannot file this form from within the US. The reason there's confusion around that is you cannot get parole while in the US. You have to leave the US and then get parole when you re-enter. We'll talk a little bit more about that. But the fact is, you can file the I-941 from outside the US or within the US. And you'd file the required filing fee and biometrics fees. Biometrics is fingerprints, the fee the government charges for all that. The total fee as of September 2021 was $1,200 to file the form and $85 for the biometrics fees. Once USCIS has approved the form I-941, the applicant would then have to do their biometrics, and they'd either do that at a US consulate or at a USCIS field office. And finally, once the biometrics have been submitted, the applicant would go to their consulate with the approved I-941, and they would get what's called a boarding foil in their passport, and that would allow them to board an airplane and travel to the US. So again, they would not get a visa. They would get a boarding foil, and that's what the airline would look at to say this person can board the plane, we can take them to the US. Once they get to the US, essentially they would provide their form I-941, their approval, to the border officer, and the border officer at that point would admit them into the US, would parole them into the US on the IEP program. So that is the point at which they receive parole. They don't receive parole at the consulate. They only receive the boarding foil. Parole is only granted at the port of entry when they're allowed physical entry into the US. Canadians who are traveling directly from Canada can present an approved form I-941 at a port of entry without first getting a boarding foil from the US consulate. So they don't have to go to the consulate for the boarding foil. Canadians do qualify for an E2 visa. Those are being processed. Toronto is a great consulate to apply through. They are experiencing delays, but they're a great consulate. So if you are a Canadian, to be completely honest, the recommendation would probably be to apply for an E2 visa rather than IEP. But there may be reasons you're considering IEP, in which case feel free to reach out to us if you'd like to discuss it. What about family members? If the entrepreneur has dependents, meaning a spouse and or children, and they want to accompany the entrepreneur, meaning go with them at the time the entrepreneur enters the US, or if they want to join the entrepreneur later, they would file a Form I-131 to request parole. So the I-131 is a travel document application. It's what you file with the government, and the government then gives the person the ability to enter the US, or if they're already in the US, to leave and enter the US. So the Form I-131 can be filed either with the entrepreneur's I-941 or later. Once the Form I-131 is approved and the spouse is paroled into the US, they can then apply for work authorization by filing a Form I-765. Children cannot apply for work authorization, only the spouse can. As a condition of parole, this is a point that's oftentimes forgotten. The entrepreneur must maintain a household income that is greater than 400% of the federal poverty line. That would be, last I checked, $51,000 for a household of one, almost $70,000 for a household of two, and almost $88,000 for a household of three. So that is not insignificant. So that all covers initial parole. Remember, that's a 2.5-year period. At the end of the initial parole period, the entrepreneur does have the option to apply for another 2.5-year period. The requirements are very similar to the ones for initial parole. The government is going to look at, first of all, the government's going to make sure the business continues to operate, which makes sense. If the business doesn't operate, the individual is not going to be eligible for IEP. The second requirement, the entrepreneur must retain at least 5% ownership interest in the business, and they must continue to play a central role in the business. They must be active. They can't be passive. If you remember, the initial percentage they had to own was 10%. So it's 10% for initial parole, it's 5% for re-parole. And it is okay, once the individual gets initial parole, it is okay for their ownership share to drop below 10%, but it always has to be above 5% if they want to apply for re-parole. So they can sell equity in the business. They just need to make sure that that ownership share never drops below 5% during the initial parole period. The business also must have achieved one of the following during the initial parole period. It must have created at least 5 full-time jobs with the startup business. It must have received at least $528,293 in qualifying investments, government grants or awards, or a combination thereof during the initial period. Or it needs to have generated at least $528,293 in US revenue and average 20% annual growth during the initial parole period of 2.5 years. So the reason these numbers look a little funny is that they are pegged to inflation. So they did go up a little bit from the initial dollar amounts. Okay, so as with the initial parole application, there is an alternative criteria. If you do not satisfy this third criterion, this either creating jobs or generating revenue or receiving a qualifying investment, you can provide additional evidence of the startup entity's substantial potential for rapid growth and job creation. And this is going to look a lot like that list you looked at before, which we have right here. So this list of what alternative documents the individual can provide is the same for re-parole. And again, this slide, and you'll get these slides after this presentation, lists the actual documents you can provide to show each of those items. So let's return to some common questions. I touched on this just a minute ago. What is the percentage of the business that the entrepreneur must own? For initial parole, they have to own at least 10% of the business to receive that initial approval. Once they receive the approval, they have parole for 2.5 years. During that 2.5-year period, their ownership share can drop below 10%, but must always be 5% or above. When they apply for re-parole, so that second 2.5-year period, their ownership has to be 5% or above. Once they're approved for re-parole, they receive another 2.5-year period. And during that 2.5-year period, their ownership can drop below 5%, but it always needs to be above 0. So they always need to have some ownership share in the business. Does the entrepreneur need to personally invest their funds? The answer is no, and this is part of the reason why IEP is attractive as opposed to the E2, which does require some amount of investment, typically around $100,000, though could be less depending on the application, and the EB5, which has a significantly higher investment amount of at least $800,000. So IEP does not require that the entrepreneur invest any of their own money. It can all be from qualified investors, such as venture capital firms, startup accelerators, the government, etc. How many people can receive parole for one startup? Up to 3 entrepreneurs can receive parole for a given startup. Can the entrepreneur travel using international entrepreneur parole? This is an interesting area. So because it's parole, you technically cannot travel on parole. Again, you're granted parole on each entry into the US. So like I said before, if you have an approved I-941, the border officers are supposed to approve your entry, your physical entry on parole. So technically, they are supposed to let you into the country even more than once if you have the approved I-941. However, that being said, parole does not give the individual the ability to leave and come back in. So legally, the answer is no, you cannot travel on parole. Practically, if you have an approved I-941, the border officer is supposed to let you in. Now, you can apply for advanced parole, which is the form I-131, which as I mentioned is a travel document, is a request for a travel document. If you're approved for a form I-131, that gives you the ability to travel. So once you have that, you can enter and exit the US. Now, family members also need to file the form I-131 in order to travel. Does the international entrepreneur parole rule lead to a green card? The answer is no. Basically, as we've discussed, the program only permits entry for 2.5 years and then an additional period of 2.5 years if they're approved. To stay longer, the entrepreneur needs to find an alternative visa status after that 5-year period. And that leads us to this final question that you see on the screen, which is, can the entrepreneur change status or adjust status in the US? Adjusting status means apply for a green card while they're in the US. Changing status means applying for a different status, such as E2 status or student status or TN, treaty worker status, from within the US. And the answer is no. The reason is that when a person comes into the US on parole, they are not technically admitted in a way that allows them to change their status. So in order to change status, I'm going to use the word change status. In order to have a different status in the US, you actually need to leave, apply for the visa at a consulate, and re-enter the country. You cannot change status from within the US if you're in the US on parole, because parole is not considered a legal admission to the US. Now, to get back to the question, does IEP, the International Entrepreneur Parole, lead to a green card? The answer is no. However, the way immigration law works in the US is that you have to independently qualify for the green card. So the US doesn't have a kind of point system that some other countries do, where your prior activities give you points, and using those points you could put them toward permanent residency. That's not how it works in the US. In the US, you have to qualify based on the requirements of the green card. So if you say we're in the US on parole and you get married to a US citizen, you may become eligible to apply for a green card on that basis. If your business that you're developing while on IEP becomes large, you receive distributions from the business, you reinvest $1 million into the business, and it creates 10 jobs, you could become eligible for an EB-5 visa. But each of those visas, each of those green cards has its independent requirements, and you just have to satisfy those requirements to become eligible for the green card. Now, again, you can't adjust status from within the US, so you'd have to apply for that at a consulate, but you could qualify for the green card based on those bases. So that completes our presentation. I have not received any questions, although feel free to send them in. We do have a few minutes. I will close by simply reiterating something I said before, which is that unfortunately, in spite of the excitement that a lot of prospective applicants, a lot of entrepreneurs, and immigration attorneys had at the start of this program at the announcement in May 2021, in spite of that, the government really has not done anything with this program. We're not aware of a single approval since May 2021, which is really sad. It's confusing. It's unclear why the government has not acted, and they have said nothing about why the program is not operating. But the government is accepting applications. So the process is in place, the form has been released, and the government has said that they are accepting applications. So, if you are interested in IEP, you can prepare an application and get in line so that hopefully once the government starts to adjudicate these applications, you have your place in line. But in the meantime, I would recommend that those who are eligible for an E2 visa or another option, maybe the EB2 national interest waiver or the EB5 green card, consider those options, because we're really not sure when the government will make any progress on IEP. So please do, if you have any questions or want to discuss your specific situation, please do reach out to our firm, schedule a consultation on our website. We will be following up after this presentation with the PowerPoint, copy of the recording, and a link to our YouTube channel, as well as where you can sign up for future webinars. So we do hope to see you on those. Thank you so much. Have a great day, and thank you for taking the time to join us.